We call in now even greater awareness of our divine and benevolent Creator. While we increasingly carry this awareness with us throughout our daily activity, we call attention right now to express our gratitude. So much gratitude. Gratitude for the closeness and love of family and friends. Gratitude even for those individuals we may not agree with, for they help us to see ourselves. We provide a mirror for one another. We get tempered. We see and feel what comes up with the diversity of thought, opinion, and action. We get honed. We are forced to introspect and grow. When we go to gratitude, when we go to love, when we call you in, we can allow ourselves to melt into a greater understanding of your grand plan and how we are given the free will to move within it. So we humbly give thanks for every moment of this dynamic, living, breathing, moving expression of our existence within the greater context of your elaborate and exquisite creation, the all that is, the ever-present love that is here at any moment of our choosing and recognition. And so it is.
Thank you, Charlie.
My pleasure.
My name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. I'm here today with Charlie and William and several people audio. Say hello, you guys.
Hi.
Hello.
Hi, Charlie. This is Richard.
Hi, Richard. Glad you're on.
Hello, Brandon's on.
Good, Brandon.
Hi, Brandon.
Howdy.
Cheryl.
Hi, Cheryl.
Brandon. Richard.
Yes.
Raymond.
Ray.
Mark.
Mark.
Pretty good crowd. Some people showed up. Nice. I got a few things I'd like to say. Then we're going to have a pretty good conversation over something that came to us, and we have to be careful of the law of unexpected consequences. So, to the best of our ability, it's mindset. The Oregon Statewide Jural Assembly is Article 1, Section 1. Natural rights inherent in the people. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness. And they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper.
Amen.
Yes, it has been acquiesced to many times by the feds, the state of Oregon, 38 prosecutors, 36 sheriffs, and more. Their de facto color of law governance of the incorporated defunct United States of the post-March 1861 is fraud upon the people, including all of the color of law subdivisions such as State of Oregon and its counties and cities are nullities in law. They function because they have indoctrinated the people into believing they are persons and subjects of their color of law. If 200 million people believe something, it is de facto. One cannot make flat statements, as there is always exceptions. We are dealing with sovereign men and women with their children. This is from an old man who knows less than the old man who knew nothing. Rest in peace, Arnie. Constitutionally, lawfully on Oregon and every one of the several states and territories, the place for people to find lawful remedy against the state is in Article 3. There is no Article 3 court provided by the feds. The United States, Inc. refuses to claim original jurisdiction. It cannot. It is an incorporated entity. They cannot claim jurisdiction over a man, only over the straw man. We must do it ourselves. That's clear. SCOTUS has decreed that the feds are not required to provide an Amendment 7 court. That's clear. The Constitution says that men going against the state in all these different ways do it in Article 3. Then the corporate governance made a rule stating that all courts whose name begins with the United States is not an Article 3 court. That's in Bukini 301. They went around and changed the name of every court so that it cannot be an Article 3 court because the name begins with United States Federal District Court of Portland and so forth. They made it impossible to get there through them. And all of these people that are persons out there trying to reach remedy through de facto, I don't see how they can get there. We have to do it ourselves. Nobody can do it for us, and we can't do it alone. Here's the thought that we're going to be talking about today. A claim of cognizance states that this is between one court and another. This is one court telling another court, you do not have jurisdiction over the named first person people because they're in our jurisdiction. And our jurisdiction is de facto. Therefore, if Fred's out here and Fred gets a ticket and he writes on the ticket, I don't want to do contract with you, and he turns the ticket into the clerk of the court and he has proof that he did so, they either stamped a copy or he took a picture or he's got two people that were there and witnessed it. He's not in contract with them and he's not responsible for their justice court criminal activity against him for a traffic ticket.
Right. We got to remember that every time they approach us, they're coming to us with dirty hands.
They are.
And they want money for it.
Every time.
I know I've heard you say several times that these people out there trying to get the remedy through them is like picking up the turd from the clean end.
Yes.
Right. So you reach out there and shake their hand. They have dirty hands, and now you're going to have a dirty hand too. It's really horrible. I've been in some of these courtrooms and stuff, and I've seen the actions. I've seen lots of video footage of this activity out there, and they're just horrible. They don't even obey their own rules.
Well, if
Yes,
you think about the fact that money is made up and it's lent to us and we have to pay debt, we're indebted to them so that we pay them with the debted money that they give us to pay them debt.
Yeah, which is impossible, right?
It's
Yeah,
like
how do you pay a debt with the
double
debt?
indemnity.
So when I was talking to this guy, we'll call him Fred, about his traffic ticket, the thought crossed my mind that if our court, our de jure court, wrote a claim of cognizance for that court saying, you don't have jurisdiction over Fred, leave him alone, then that should hold with every single court in the county where he lives. Don't you think?
Yep.
If he, yeah. Well, then he said to me, "What about family court?" And my whole brain exploded. He's right. But God, the unexpected consequences of that. I brought this up to a person. No, I brought this up to one of the people, and she said, "Yeah, you're right. But what if one of the parents that accepted the jurisdiction of family courts is a real butthead and would grab the child and run to Arizona, kidnap their own kid away from the parent if they thought they could get away with it and there wasn't a court with jurisdiction over them?" Yep, unexpected consequences. But how are we going to deal with these things when we have a family court that has no business telling two adults, sovereign Oregonians, how to settle their own business? Now, if those two adults were persons when they did this several years ago, and they didn't know anything about being one of the people other than reading it in the documents and not comprehending what it meant, and they agreed to the decision of the court, that person becomes aware that they're one of the people, and they change their jurisdiction to that of a man instead of a straw man, and they are no longer the all capital version of their name. They become the flesh and blood de jure man. When that happens, that man or woman can claim their jurisdiction, and they can step back and forth into the de facto or the de jure, or expatriate, as we call it, from the de facto to the de jure and back again, to deal with these situations that have arisen. And I yield.
I want to hear from Fred, who is aware of this personally. Can we have a comment from whoever that is?
Well, if he wants to identify himself as Fred, he can come on board for sure. He's on the call, but I haven't identified him.
Okay, well, that's... you want to come on, Fred?
Sure, hey. This is Fred.
So what are you doing in family court, being a man?
Nothing at the moment, but I did have a court order from a judge within the family court that is supposedly the final judgment of a divorce and child custody.
Okay. And how did you come out?
I think it's pretty fair, but...
Say you were going to come out. Okay.
I don't understand your question, I guess, as to what you're asking. As far as the outcome goes, I'm satisfied knowing that I feel like it was a fair decision. However, moving forward, they believe they have jurisdiction over any decisions that I were to make if I decided to move with my daughter, or if I were to want to, there's a set schedule that they require be upheld, which hasn't been a problem between me and the mother thus far. But should that go south at any point, I don't believe that their courts have the legal rights to make determinations between our issues.
Okay, do you have a better idea of who might have that kind of discretion? A mediator.
Yeah, very well.
Your ex, do you and your ex have a common friend who could mediate? Do you run in the same circles to that extent?
No. But I mean, that's a service that could be paid for, I'm sure, or that could be worked out at some point if that were the case.
Okay.
We both would reach a specific mediator.
Well, just to let you know, in 1993, I think it was, there was a mandatory mediation law enacted. So if you, and that's in the de facto, but if you had the cash reserves to hire a mediator, you would be satisfying that. So there wouldn't be any question about the legitimacy. It would just be a moot point. And then you could do it yourselves between you, the mediator, and your ex. But that's the obvious. And as long as you do it yourselves through a third party, the courts have no jurisdiction. That they enacted this law. That goes first, always mediation. And, so if you, as long as you do that, as long as you adhere to that, the courts cannot even claim. That's the issue here, is the courts claiming jurisdiction when they don't have it. But you can avoid that.
So, Richard, is that a way that a couple or two parents can eliminate the court's involvement if they approach that through that means, through that law?
Absolutely. Absolutely. Okay. Mediation does not require a license, or, I mean, the mediator does not require any paperwork. It can be your preacher, it can be your kid's scout leader, it can be the grocery store clerk. It doesn't matter. A mediator will satisfy everything in that law.
Richard,
You just call him a mediator.
Richard, would you give us the number of that, please? I know you got it in your head.
No, I'm sorry. I don't have that in my head.
Wonderful.
A rare moment.
I trapped you. I can't believe it. Well, as you have said to me, Richard, Ron, did you read it? Yeah, I did, Richard. Well, then why didn't you remember it? Oh, I feel so good. Thank you.
Well, I was very disappointed in that because most of the mediation that's done officially, close quote, by the de factos, is done by a team hired by the court to do it. If two people can't come up with their own mediator, then this is the last resort. You go to the court, and there's one there. And that bugged me to no end, to the point where I didn't want to remember it. I was so pissed. I was aggravated.
Yeah, I'd like to add on to that, because I actually was given a requirement that needed to be met, that we would first go to, like you said, a mediator, and I showed up, but she didn't. So at that point, You know, I mean, attorneys were involved as well and whatnot. So, you know, I ended up having to go to the court, or at least believed at the time that I did. So,
Okay. Well, don't go to the court. What and cultivate the relationship between you and your ex to the point where you can agree on someone other than the court. Because if you get the court mediator, you're going to get a de facto job. They're not going to treat you like a human being.
You're also most likely going to be required to get an attorney, or suggested to get an attorney, which is going to entail tremendous cost and a lot of time, because it's the back and forth between the defendant or the whomever is being advocated for by the attorney. So there's a lot of cost and a lot of time involved. So that also is part of the court system.
Yes, basically like a spider web. It entraps you. It'll drag you in deeper and deeper over time. I spent a lot of time with child support issues and stuff like that for many years, and it just entangles you. They want to know where you're living, and if you move, they threaten you. They'll take your driver's license away if you don't tell them when you change jobs. It's just a nasty, nasty mess. If you can stay away from those people, you're going to be way better off.
Well, and here's the thing.
Okay.
We really need to start taking responsibility for everything within our lives. We shouldn't be depending on the authorities or the experts or those who are licensed or certified or anything. We're moving to a self-responsible form of self-governance. Common law requires that. So isn't that a wonderful thing when we recognize that we don't need to be dependent on people who think they know more about our lives or our activities than we do or should take responsibility for?
anyway, yes, the reason where this all came up and stemmed from was the fact that I myself as well would like to take more of that responsibility rather than push it off to the courts. But now that was just disclosed, you get more entangled. That's where I'm at. So I'm not having any issues right now. I just don't want to have to go back into and get stuck in that web. When I'm currently in a good place, mother and me are able to communicate and figure things out. But should she get a hair, and want to go to the courts for something down the road, I want to prevent that situation before it comes, knowing that I'm not under their jurisdiction. So that's where this stemmed from.
Okay.
Ron?
Let's talk about how close are you to mother? You talk to her
Physically?
on a monthly, day-to-day, what kind of basis do you have any communication?
Yeah, we discussed scheduling issues. Another thing that came up last night, my daughter Zoomed me. She was pretty upset. I guess her mom and her mom's boyfriend were arguing, and she was pretty scared at the moment. And so this morning, though, I got a call from her, my daughter's mom, and she was saying, "Oh no, she was just worried because we stepped out of the car to talk and whatnot, rather than in front of her." And so, at this moment, we're on pretty good terms as far as communication goes. I can pretty much just talk to her just about anything.
Oh, okay, that's a good place to be in. And so while you're in this kind of place, I'm strongly urging you to select somebody that you both know to function as your mediator. Someone who cares for your daughter would be my first choice. Someone who knows your daughter, someone who's been involved with your family's life for a while would be my first choice. But and you just make everything a matter of record, put it on the record so that you show your good faith early on before there's any turmoil. There's no turmoil now, and that's the perfect time to start, is when there's no turmoil.
You have an agreement.
You could sit down to, dinner with her, or just coffee. Just go meet her someplace and say, we need to talk for an hour, let's say, and we're going to find a friend of ours who will function as our mediator on into the future. Somebody that's not going to abandon you. Somebody that will have a concern until your kid turns 18 anyway, at least 18. Is that possible? Do you folks have any?
Yeah, I'm sure we can find a family member. I'm sure of hers that we can use. So, yeah.
Okay, that's crucial. And if you can, put your agreement on who it is in writing, and that way you're not going to be at fault. And by the way, the statutes on divorce, right? You did your own divorce, right? You're talking 107, chapter 107 of the Oregon Revised Statutes.
No, I didn't do it. I mean, I had an attorney do all the paperwork. It was almost not an option. Yes. Her mom was involved with drugs, and so she ended up having to have her mom come in as an intervener. So grandma's involved as well, and also has parenting time, technically according to the court's order as well. That's why, again, as well down the road, should something happen to my daughter's mom or whatever, I don't want to have to deal with the courts telling me that grandma now also has an interest within my daughter's life outside of, her parent, or regarding being with her parent.
How much time does she currently spend with your daughter?
Very little anymore. But at the time, she was granted the majority of her mother's parenting time.
Okay. So clarify that. I mean, would she possibly be the mediator?
No, I wouldn't trust her to be a mediator.
Okay, and she because she's an interested party, she cannot really qualify as a mediator. But
Right.
The point that I'm going to make is that in Chapter 107, in every chapter of the ORS, there's a definition list at the beginning, right? And in this particular chapter, there's no definitions. So it doesn't describe who is married, who is divorcing the persons, the husband or wife. It doesn't describe any of those. So they're talking about you are a corporate entity. You are licensed by the state. You are subject to their jurisdiction. But you have at all times a right to alter, reform, or abolish the government. And you can at least abolish them from your life, from your daughter's life. And that's what you're trying to do right now, right? You want to make sure that the de factos, don't get any opportunity to dictate the terms of your daughter's life, right?
Exactly.
Okay. So just tell them that. Say, I'm not a person. I'm not your typical husband. Do you remember the Jack Solis material that I ended up getting about a license?
Yes, from the archives. You got it.
You got it from archives. So keep that in mind. That is crucial information. And I would say get another copy of it, or ask me to send, I can send you a copy of it if you need me to, but you're right there. But it's permission required by law to pursue any commercial activity, trade, occupation, or profession, including the business of being a family member, a husband, which means that you get to file joint tax returns, which means that you're a corporate entity, which means that you're subject to the law. So keep that in mind. That's a crucial piece. It's all so tied together. If you're a man, you're not licensed. I'm not saying that a license is not a good thing at times. It can be, it can open a door, but a man has the right to contract under Article 1, Section 10 of the U.S. Constitution. And we don't need a license to contract. Everybody has a right to contract. No law shall be passed impairing the obligation of contracts, right? So just see if you can get another copy of Jack Solis's statement about licenses. Or ask me now to send you another copy.
Yeah, that would be nice.
Okay. I'll send it to you. I'll make copies and send it to you. Oh, and that was so amazing to get that. I've been quoting that for years, but I've never seen the bill. And to get it was so amazing. And thank you.
Absolutely.
Boy, what comes around goes around, doesn't it? Richard, thank you so much for that information. It looks to me like the claim of cognizance for anybody that we're going to write a claim of cognizance for, if we write it specifically, well, like we did for Richard, specifically to the district attorney of Marion County to eliminate a warrant. That was a specific claim of cognizance. The same thing for Mike down in Eugene. But the original one we wrote for Oregonians, that's for all Oregonians in all courts, as I remember. Mm-hmm. We may not have specified that, but I'm not sure that it counts. But if we write a claim of cognizance now for somebody, I think it should be go to the trouble of figuring out how many courts there are in your county that are liable to have any contact with you. Like for me in Washington County, I'm not going to get into family court. There's no way that I can imagine me getting into that court. But people with children, they've got a way on that. They can go into the school and say, we have reason to believe your parents are whatever, and confiscate the kid, and by court order put the kid into protective custody and child care, and just actually kidnap your kid legally by their de facto court. So that is a real issue with a lot of people that have kids. They should be able to notify the family court for $1.55 served to them through the Universal Postal Union Treaty that I'm a de jure man and you have no jurisdiction over me. And the reason for that is there's a claim of cognizance from the Oregon Statewide Jural Assembly Civilian Court of Record that the de jure man and woman on Oregon are in our jurisdiction, not in your jurisdiction. And what, for a person that's got 4 or 5 courts that they may be dealing with in their lifetime, probate court, bankruptcy court, traffic court, all of those courts, if you got a claim of cognizance from our court and notified them all, it'd only be $1.55 a court to have proof that that court has been notified by you. No, notified by your court that there's a claim of cognizance in there. And I saw that Cheryl wanted to talk.
Go ahead, Cheryl.
I was just going to say, wouldn't it be a better way of saying it instead of I am a man of the de jure? Wouldn't it be better to say I am a sovereign man and only the de jure has jurisdiction over me?
Well said.
Mm-hmm.
Thank you.
Excuse me, Richard wants to say something.
Go ahead.
Currently, we're talking about a situation where a final judgment has been entered, and there is no claim of jurisdiction at this time, and it's only subject to one of those parents seeking jurisdiction of the court that's going to change that. And a claim of cognizance is an argument between 2 courts over typically a person, but in family court, it's always over 2 people, a family, a former family. So I'm not sure that the claim of cognizance is applicable in this instance where there is no pending anything. I think the best thing to do is just preclude any possibility of jurisdiction being asserted by saying we have a mediator on a permanent basis and this person is interested in our kid and wants to have the best outcome of any discussion fall to the kid. We want the kid to have the best of everything. The parents count less. It's just, the court always talks about the best interest of the child. And that's, if the best interest of the child is looked over by somebody that can be counted on by both parents, there is no jurisdiction for the court to have. Do you get that?
Yeah, and I don't agree with it. I think that you're moving right back into working with the de facto, and the only way that Fred can deal with the de facto without expatriating to the de facto is to go through a court where there is jurisdiction, and for that court to notify the other court. Because if Fred goes to that court, Fred is giving them jurisdiction. He's in fact offering them entree into the decision-making process. And I think that here's what I think. If Fred says, I want to have a mediator do this, by the de facto law, that is a way to do it. And that will satisfy.
Oh, I don't say that. I don't say that. I didn't say that.
Wait a minute.
I
Come
didn't
on.
say he should do that.
Wait a minute. Come on. Let me finish.
Don't put words in my mouth, though.
I didn't say you said that. I'm sorry if you thought that.
Okay.
The man that is looking to solve this problem in the future is saddled by a final court order from the de facto that he, in a previous iteration, agreed to, and his former wife agreed to, and that has to be obliterated. The only way you can obliterate that, in my mind, is to say, I am not in that jurisdiction. Okay, now that doesn't always work. I told that to a judge and he put me in jail. So that one doesn't really work all the time. But if another court, another lawful court, tells the court that gave that decision or final judgment that you're no longer in this, you don't have a place in this, those two people that have a child are going to do it with their own mediator and make their own decision as is authorized in your de facto law 107. That's basically what it is, I think. And then the person that, no, one of the singular for people being person, not a corporate entity.
Okay.
Fred, for example, Fred says, I'm a man. Okay, so then is your child of you? Yeah. Were you married to a woman? Yeah. Is the woman body, mind, spirit, flesh, blood, and soul? Yeah. Then she cannot be the all cap version of her name that was in the document that the court, the family court, erroneously issued a final judgment on, and we're going to vacate that judgment with a claim of cognizance, and we don't need her authorization to do so because you can just look at her and there she is. She is a woman. She's not an all cap version. You have to be in a fiction to believe that. And I yield.
Cheryl, you've had your hand up for a while.
Here, Ron. Okay, so that end part is the first thing that I was going to get to. Okay, when was this verdict handed down by the de facto?
Fred's got to answer that.
At least over a year ago. But with that being said, it never, I don't know if it ever actually finalized, like that they ever actually, long story short, the attorney that I had, I sent him back the paperwork telling him that I'm not signing the final document because my name was not correctly written because it was written in all caps. And so I don't know that he ever was able to forward that off to the judge. It just kind of went out of nowhere. So that's, again, why I'm trying to make sure ahead of time that my ducks are in a row.
Well done.
As I see it, you have a court, don't matter what court, could be a foreign court, that gave you a verdict of two persons, of which two persons should never be taking care of a child. It's a piece of flippin' paper. There is no way you give custody to a piece of paper. Therefore, you have had the strength of will to seek an appeal in the true court with original jurisdictions that presides over people on the land of Oregon. Therefore, this court should make a claim of cognizance, informing that court that they have no jurisdiction over the people on Oregon, only the corporations, and to get their job straight.
Outstanding, Cheryl. Thank you.
Richard wants to address that.
Go ahead.
Ready?
Yep.
A court, any court in any state has one function, and that's to resolve controversy. This controversy was likely resolved. We don't know exactly what the attorney did with the paperwork. It's something that needs to be found out. I don't say leave it as is. Find out what's going on with that. If it has not been finalized, if there is still jurisdiction asserted by the court because it's not finalized, it's still going, the controversy has not been resolved officially, then maybe the claim of cognizance would work. But if there is no current controversy, nothing for the court to resolve, it would be out of place for a court to claim jurisdiction over a non-controversy. Courts don't do anything except resolve controversy. That's what a claim of cognizance would be about, and is which court gets to do that. So if there's no controversy going on, then I don't see the need, I don't see the appropriateness of filing a claim of cognizance with the de facto court.
There are two hands up.
It's just not there.
Okay, go ahead, Ron.
Just take a note down and say we're going to take care of it for the rest of our lives.
Go ahead, Ron.
I think the claim of cognizance has nothing to do with either parent or child. All it is doing is informing another court, and there doesn't need to be a controversy. It's just informing the other court, with or without controversy, you have no jurisdiction over these three people.
And I also see it as a waylay for any kind of interaction or action that's taken by the court on behalf of or against either of the parents unexpectedly. Let's say one parent goes to the court and wants to bring up an issue or has a child custody issue, and all of a sudden the state gets involved, the county, whatever. I think it's a way to head off any kind of preliminary or, ensuing kind of activity that might occur unsuspectedly. So it's a preventive kind of thing. That's how I see it. Go ahead, Cheryl.
Cheryl?
Okay, it's working. Okay, so it's simple. They made a verdict. Fred, let's go. Fred is appealing it through the de jure court, the proper court. The de jure court is notifying the de facto that they have no jurisdiction, that we will hold this court in appeal at our station, that this is our man, he's a living, breathing entity, and we will decide from here the course of action that will be set. It is, I think, something that we should do with each proceeding is we send off information that our court is taking this jurisdiction. We have original jurisdiction. You can manage the corporations, the all caps chattel that goes with human beings, but not a human being. a person, we will take on our own. Sorry, I'm stumbled. I yield.
Is this something that our court would handle? Is the case between the parents and the child? Is that something that would be taken on by a court of ours?
We
People.
could,
I don't see that it would be, because
probably not.
I think that, our position is that of jurisdictional consideration. As far as the specifics of the issue, like Ron says, we could, but I think the mediator is the solution. And that actually how I see common law working, because we're all taking responsibility for ourselves, is that we have to find the remedy within our jurisdiction. Once we've reserved or rescued a people from the wrong jurisdiction, and they're claiming they're taking responsibility, then it's their responsibility to find remedy within the proper jurisdiction. That's how I see it, and I yield. Ron?
I agree, unless you're going against the state. And then if you're
Yeah.
going against the state, then you need us to go against the state for you, because there's no other court. And I
Sure.
yield.
Yeah, I see it that way too.
I think we put together a pretty good show. Do you think we can wrap it up now? Anybody got more they want to say?
I'm good.
Richard yields.
Thank you, Richard.
Thank you, everyone, for being here.
Agreed.
orsja.org.
Please. And mark it that you liked it.
Please.
I'm out.
Good night.
Thank you, everyone.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, "Just shoot me then. This is what you want, just shoot me." And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.